All right, we're here today with my good friend Sam Goldstien. We're in Toronto at his office. Sam is very graciously taking time out of his day to talk to me here. We are going to talk about Sam's well-known, he's a 16-year call, and he's one of the staples, one of the a well-known criminal defense lawyer in Toronto. And I think it's interesting because Sam and I were talking about this. We physically met last year back in Calgary, and Sam has actually a relatively interesting I don't know if the practice or reputation within Toronto, and this is sort of my subjective assessment. He's kind of seen as one of the guys, and here's Sam, and he's a known quantity. The name Sam Goldstien, I personally, before I had met him, I'd already heard of. I'd already heard of the guy, and I think that's actually quite common. I think there are a lot of people where Sam doesn't practice. Alberta would be one area, and other places that do know the guy and know of his work, and his reputation does precede him on that. Definitely, I'd heard the guy before he was out giving a lecture on these things. So I'm very glad that Sam, and also in the interests of full, fair, and frank disclosure, Sam is a good buddy of mine, like most of the people we're interviewing here. I'm not impartial on the guy. So what we're going to talk about, and I'll be putting this in the comments section below the video, would be the Ferron case, and I'll give you a cite for that. Sam was in fact lead counsel on this. I believe it was for Mr. Ferron, and what we're going to do is we're going to talk briefly about what Ferron says. I know that's not, I'd like to do that, and then we've got other things that we want to cover as well. So Sam, maybe you could just sort of, and keep in mind we're talking to law students here, and there's a lot of great things about going to the Supreme Court of Canada, but could you just give me the Coles Notes version, or the head note version of what Ferron's about, and explain that to me, please?
Okay, so Kevin Ferron was charged along with two other people for a robbery outside a flea market, and it was a robbery at gunpoint. He and his colleague were found outside their apartment a couple hours after the incident, and when the police arrested my client, Kevin, they patted him down. And in the course of patting him down, they found a cell phone on his person. It was in his pocket, and as a result, a police officer was looking through the cell phone, found a number of incriminating texts and a number of incriminating photographs, and used that at the trial to link him to the robbery.
Okay, all right, fair enough. I think I understand that. Now, we were talking just a few minutes ago. You were talking about. I believe you were indicating that you're focusing on how the court made the decisions, and things like that. And that was what you, because I know you've got a lot to say about this. I heard.
Well, let me just start a little bit more. So, in terms of the case, then what you have is that you have a search instant to arrest.
Right.
Right. And the question became did the police have a right to look through a cell phone search instant to the arrest? Was it a breach of the Section 8? Because you remember, without having a warrant, then it becomes a warrantless search, and therefore it falls upon the Crown to prove why it should be, could it be authorized either in statute or in common law. In this case, there's always been a common law power for police to pat someone down, and the purpose is quite clearly for the search instant to arrest. The common law power goes back to Langlois and Cloutier, which is a Quebec case. And there, the Supreme Court found in, I think, early 90s, was that the police have the right to pat you down because they want to find if there's any evidence on you, they want to preserve any evidence that they find it on you, and they want for officers' safety in case you have a knife or something, right? So for those purposes, they could pat you down. So the officer was patting Kevin down for the purpose of officer safety, looking if there's any evidence on him, and if they did find any evidence, then to try and preserve that evidence, right? But the question becomes your expectation of privacy is very high in a cell phone, and if that's the case, then maybe you should have a warrant to look at the cell phone. And so the court and in addition to that as well, not only high expectation of privacy in the cell phone, but you also have a sense in which in a cell phone, it's not in terms of officer safety. I mean, so you found the cell phone. Why do you need to then go in to look at the cell phone, right? Because it's not, if there's a photograph of a gun on the cell phone, then certainly that photograph isn't going to be able to shoot the officer.
Well, no, yeah.
So you have a diminished
officer safety has to be a pretty. I mean, how could it come up at all?
Right. And then in addition to that, you might be able to find some sort of incriminating photograph on the phone, but then that can be preserved by just simply turning the phone off and seizing it. So you don't have to actually start searching through it to preserve the evidence. So you have an undermining of the policy considerations involved in the search incident to arrest. And then you have in addition to that, you have the high degree of expectation of privacy in the phone. And just prior to Fearon, there's a case called VU, which was the officers go into, from BC, you go into a home on a search warrant, but the search warrant doesn't say that when you're in the home you could actually search the computer that's found and a cell phone that was found in the home. In that case, that was really the turning point in the Section 8 discussion. Now that just happened a few months, the decision in VU came out a few months before the deadline for my factum in Fearon, but which made me I had to rewrite my whole factum. But the key in the VU case was that, number one, there was a lot of discussions prior to VU whether cell phones were like computers, because you had different types of cell phones. So a lot of the jurisprudence was distinguishing between, aka smartphones or dumb phones. So flip phones versus a BlackBerry or
which probably don't even exist anymore. Right?
No, well, the BlackBerry still exists, but
sorry,
right.
I meant the dumb phones, right?
Yeah,
not BlackBerry.
Yeah,
I know people
or
do
feature
sell
phones.
Feature
phones is what they're actually called. But there was the Palm Trio that was out at one time. That was a case in Newmarket, just outside Toronto, called Little, which the court said that there's no evidence that the phone was hooked up to the internet or something like that. So it was making these distinctions in terms of the phones, right?
Right.
VU said there was no distinction between a computer and a cell phone, so that was an important leap forward.
Right.
Eliminated that issue. And the second issue VU said was that these computers had a high degree of expectation in them, because the amount of information that was carried in them. So the quantitative amount of information meant a qualitative difference. That they were fastidious record keepers, that they're always keeping records of things. Right. That they're possibly interconnected to other cell phones or other computers. So if you're searching here, you're actually searching potentially somewhere else. Right. Now that was a real paradigm shift in the thinking of Section 8. And just to go back to the case was because the Crown was arguing that a search warrant says you could search anything, right, in a home. So is a computer like any other thing in a home? Is it particularly like some sort of filing cabinet? Right? And the Supreme Court, by going to the VU case, the Supreme Court in the VU case, when they rethought what computers are all about, they said, well, they're not like all other things. They are sui generis. They're not like filing cabinets for the reasons that I just articulated. And so going into Fearon, those who were supportive of the applicant's position thought we were going to win in it, because the court had sort of made this paradigm shift that we were no longer talking about three-dimensional space. So you think about back in the Langlois and Cloutier case, when the officer pats down, I think it's Mr. Langlois, I can't remember who the officer, I can't remember who the people were in that case, the officer or the individual, but I think it was Mr. Let's say it's Mr. Cloutier, who was he's actually a lawyer in that case, who was speeding, and the officer arrested him. But so in that case, you could think that versus Pierce. So in that case, what happens is you think about it. The officer's patting down the guy, or it's a simple arrest on the street. You're patting the person down. Maybe you find some marijuana, maybe a knife on the guy. Right. But you're no longer talking about that three-dimensional space. And the court sort of got that in the VU case when they made the distinction where they said that, look, computers are sui generis, and so we're not going to allow a search warrant in the home to be used also to search the computer. You have to get a separate search warrant for the computer. So going into Fearon, those on the applicant side were very positive in thinking that, okay, the court's got it. They've made that important paradigm shift from that sort of three-dimensional space to this sort of infinite digital world in terms of where information is connected. Unfortunately, I think they fell back a little bit in that decision. And the reason why they fell back, and this is what we were talking about just before, was that I think they treated the Fearon case as a case of exigent circumstances, because there was a gun out there, and the court, certainly in its peppering of questions to me and in the decision itself, makes mention of the fact that there's a gun out there, you have to find the gun, and the dangerousness of guns. The reality is not every search is going to be a situation where you're going to have a gun out there that needs to be found. I think most searches are going to be much later on, when the offense has probably happened some significant time ago, and not necessarily involving guns all the time. So I think it was unfortunate that, I think that was a certainly driving implicit fact in the judges' minds when they decided Fearon, which I think unfortunately the consequences of is the decision that they retreated from the original position as far back as Hunter Thompson, to say that if you really want to preserve privacy rights, you have to get a warrant. Right? Except in the exigent circumstances. But I think it really retreated from that Hunter Thompson line.
Well, let me ask you this, Sam, because again, and I find it fascinating. But as of course you well know, searching cell phones and guns and that's not a common part of my practice at all. So I'm relying too heavily on here. Is it your understanding then that, and I maybe I just didn't catch this subtlety, that you'd be using the VU analysis if there are not extingent circumstances, and if there are, then you'd be using the Fearon decision?
No,
or you don't think it's as strong as that? You think their rationale was the fact that there was a gun. That's what you mean?
Yeah. I mean, I in my argument, I said, look, you should have a warrant unless there's exigent circumstances. Okay, so the exigent circumstances were things like if there's a guy with a bomb or something like that, right? So I think those types of cases, and similarly, when you have the Feeney decision with respect to warrants to homes,
exactly right. Like, I mean, man beating up his wife, you don't need a
hot pursuit, things like those are all exigent circumstances. You don't need to get a warrant to go into a home. And I thought the same sort of common sense would be able to apply in the search warrant of the search of a phone. You should get a warrant except in exigent circumstances. Anyways, they disagreed with me, obviously, but they didn't necessarily agree with the Crown either, and the Crown was saying, well, you should have no restrictions on it. So the court created a balance. They came up with this theory where you have to have, it has to be rooted into the reasonable belief or reasonable grounds to believe that there will be something in the phone that will produce evidence. It has to be a lawful arrest. You have to keep you should be keeping notes of what you're doing. You shouldn't go too far into the phone or look at too many different things inside the phone. So they believed, and then they left it up to the trial courts to determine the reasonableness of the search. Okay, so it's really, you're looking at the scope of the search in terms of going forward. So they produced, they asked for some limitations on the search, so I think we got a bit of a half a loaf. The reality is, I think in many ways, this decision, while it's important for now, I don't really know how important it will be in time for a number of reasons. One, it was a very peculiar situation that we had 7 people on the court. Right? We had a situation where Justice Nadone wasn't allowed, or not allowed in court, but he wasn't called to the court because that was blocked. Right? So he wasn't sitting. That and they didn't want to have, and I think there's someone else who would step down, and they hadn't filled the position yet. And Justice Rothstein was the administrative judge on it. That is to say that he dealt with all of the, because he dealt with all of the leave applications and so on. He didn't sit on it because they wanted to have an even, they wanted to have an odd number of people, right? So it was Nadon who wasn't there, and then that would leave 8, and then Rothstein stepped aside so they wouldn't have an even number of 8. So that made 7. So you have a 4-3 split. So I think in time you'll have 2 more judges. If it ever gets back up to the court, and it'll get up on the court in terms of the scope of the search, who knows, the decision may be overruled because we'll have 2 new judges. In addition to that, I think the reality is that people are using passwords more, so I think it's moot on that level as well. All you need is a password,
Right.
right? And the police won't be able to go into your phone, and realistically, or technically, by putting a password on it, you're just simply forcing them to get a search warrant.
Right.
There's nothing that says you have to cooperate with the police, so they
Right.
can't. They may try and charge you with obstruction or threaten you, but you don't have to cooperate with the police to search your own phone. And the other thing I think it's not so much moot, but I think leapfrogging forward in terms of where I think searches are going to be. I don't think they're going to be so much in phones. I think they're going to be in cars, because now in today's world, cars are becoming so interconnected that your car in the future, and that may just be next month, will be the cell phone that we had a couple of years ago, right? And now we're seeing it all these Fitbits and these other health type of gadgets.
Right.
You know, they'll be important for GPS location, right, to establish where you were in the crime. So I think we've moved on from phones. I think Fitbits and those things are going to be out there for a little bit. I could see cases coming forward where they're going to try and seize those and try and get access to them.
Right.
But I really think the future of search and seizure is going to be the car.
Right.
Just because how intelligent cars are becoming in terms of they're becoming the cell phones of yesterday.
Now, there's a dissent in here. I only reviewed the dissent briefly. Am I right in thinking that
It's a brilliant dissent, yeah. Because
they adopted they adopted what they followed you there. There you go.
Yeah, Karakatsanis, who, interesting enough, is a Harper appointment, because we used to talk about conservatives, right?
we were
and she's
talking
a very
about Mr. Harper, you bet.
recent conservative appointment, completely sided with the applicant,
right,
in this case, and she understood and the minority understood the importance of the privacy interests in cell phones. As an aside to that, it was very interesting to me one time. I was in dinner at my house, and I had some of my cousins over. And there's a good cross section of ages at my table, and I went around. It was actually at my Passover table, Seder table, and I was asking people what was more important to them in terms of their privacy. Was it their cell phone? Was it their home? Or was it taking a hair sample for a DNA analysis, right? And it was very interesting. The older people at my Seder table felt that the most important, higher expectation of privacy was in the home, whereas the younger people at my table thought it was their cell phone. So I thought to some extent it was a
nobody said the DNA.
Well, there was a middle level of DNA, but it was basically in terms of their highest priority, ranking 1 to 2, 1 to 3 type thing, 1 being the highest. The older people said the home by far and large, and maybe the DNA and the cell phone was second or third. And by and large, the younger people at the table were saying the cell phone.
Yeah.
And when I say younger, I'm not talking about teenagers. I'm talking maybe 20, certainly under 30, and then 25 and younger. Right. We're certainly saying the cell phone to them was more important. Now, that could be in part because they don't own property, if they don't own homes. But I do think that in time, I think it was a bit of a generational issue, that people see cell phones as something very personal to them. And then, in addition to that, we see all these accessories to cell phones and how people accessorize their cell phones and put things on them and not just in terms
downloading apps and stuff.
No. I'm talking about I'm talking about the protective coverings, and there was so everyone wants to individualize their cell phone, and they want to put little jewels or paint it or make it personal.
Sure.
And I think that goes to the fact that you want to personalize your cell phone. You see it as an extension of your personality, and if you see it as an extension of your personality, then you believe there's something personal in it, and so you believe there's a high expectation of privacy in it. Okay, so I think that could
insightful.
be so, but I just don't think I don't think the court was there. Ironically, because they had just decided VU not so long ago.
Right.
But notwithstanding that, I just think they still see in their minds a hierarchy in terms of reasonable expectation of privacy, and it goes up there in terms of homes, and then maybe lockers, and then cell phones, and
and you could see it as well. I mean, like it's not a secret to get on the Supreme Court, you're a very senior person, right? I mean, you're a senior lawyer, right?
Yeah, look, you're going to be older. That's
right.
simply the reality.
Yeah,
That's
yeah.
not to say, look, I articled for Justice Rothstein
Right.
when he was at the federal court. And, you know, he thought about issues that were going on at the time. It's not as if judges are removed from society.
Right.
Rothstein has a son who's much younger than he is.
Right.
And obviously through raising his son, you know, he sees what people are experiencing,
right.
type of thing, right? So I say that only because I don't want to give the impression that I'm saying the judges are somehow removed from the you know, society. I mean, they put their pants on,
right,
you know,
right.
just like you and I in the morning.
Right. Yeah.
But I think in terms of their tastes, if I could use that word, right? I do think there's a sense in which they have a certain view of which they were brought up in the law as what's important and what's not important, right? And I could see, you know, those judges sort of think, well, look, you know, that's not that important,
right?
Because that's not what they grew up with.
Right.
That's all.
Yeah.
Where maybe another generation of lawyers will see cell phones or cars or whoever we have in the future, you know, as being more important.
Yeah, I could easily see that. I mean, that makes it, I find that very intuitive, right? You've got, I know, I read the demographics. I only recently learned how to use, for example, Facebook and LinkedIn and this kind of stuff, right? And I mentioned it.
Al, you're on.
I know we are. But I know, but
to hear that.
But I could, yeah, it's right. But
how much you use it.
Right, and the thing is, it's interesting. I remember looking at the demographics for Facebook, and you and I are about the right age of the people that really like it, right? Like my own kid, I think he said, no, I don't think anybody's ever used it, right? You know, he's a teenager or something like that, right? He's got some other thing that they're using,
absolutely,
right?
Instagram or Pinterest or some other things.
Probably something like that. So you could really easily see that, right? I mean, especially if you're in. I mean, you got to think, right? If you're in Ottawa, for example, right, it's probably quite plausible that you could get a lot of information from actual physical newspapers, right? I mean, if you're talking about very senior people, I personally prefer them. I had to switch over because they just aren't anywhere anymore. You know, they're very difficult to get. You know, but if you're in Ottawa or Toronto or something like that, that's very insightful, Sam. That's very, very interesting. Okay, Sam, I think that was everything that I wanted to cover.
Okay.
Was there anything else you wanted to? While we got you here, while we got the wealth of information that is Sam Goldstien here?
Because you know, I will say this because you told me that you want this for younger lawyers, as well as maybe a broader audience.
Yeah.
I will say that. Look, when I saw the Fearon case, I knew immediately that this was going to go to the Supreme Court.
Right.
And at the same time, I also knew that I was going to lose at the trial level, and I was probably going to lose at the Court of Appeal because the law just wasn't there yet.
Right.
So I think what I want to say to up and coming lawyers, new lawyers, and so on, is that it's simple, but just believe in what you believe in, and don't give up at it.
Right.
You know, and I knew I was behind. I knew the law wasn't where I wanted to be.
Right.
But I knew that this case was going to change it, and I believed in the position that I was taking, and I just took it at every single level. And I knew I was going to lose at the lower levels, but I thought eventually I get to the Supreme Court, I'll win. Now, I didn't completely win.
You won three out of four.
But I was right. Ultimately I was right. I knew this was an important issue.
Right.
I saw it was an important issue, and I just stuck to my guns, and I kept arguing the position over and over again. And I knew that eventually someone was going to listen to me.
Right.
And to some extent, 3 judges did in the end listen to me. And I think sometimes maybe I wasn't the majority, but dissents often in our past and in our judicial history have a way of coming back and being adopted by majorities.
Sure.
So if I wasn't successful maybe at the Fearon case, some other lawyer who is listening and watching
right
this
now,
video
in
now
law school right now,
maybe picking up the dissent in Fearon and then using it in the future.
Let me ask you this, Sam. The factum that you wrote was obviously a matter of public record. Would you mind if we put it up there?
Go ahead.
Okay.
I think it's a pretty good factum.
I imagine it is. I imagine you're well.
As I say, I had to rewrite that factum completely because you know, three weeks into the deadline of that, or even
Yeah,
less
you
than
said
the,
it, right,
the
yeah.
deadline, I had to rewrite it. So,
Awesome.
but it's a good factor.
Awesome. So what we're going to do is I'll in the bottom underneath the video I'm going to Dropbox Sam's factum. Thank you very much for that, Sam. And we are going to link to the Farron case. So Sam, thank you so much for
You're
taking
welcome.
time out of your day.
It's good seeing you.
great. It's wicked seeing you, man. It's awesome. All right. So thanks, Sam. Thanks for your time. Okay,
You're
bye.
welcome.